All right. Where are we, folks, on this?
We have
I did receive the email this morning, or the message this morning. So.
Yes, I did let him know about the videos, and then I just received them after 11 o'clock last night, opened them early this morning. We do have all of our witnesses today. It's my understanding that Mr. Hall would be objecting to admission of the videos. As a result of that, I would be requesting an adjournment so that he has adequate time to review them with his client, and we would be able to use them at the next available bench trial date. I do want to note for the record that I did previously request all media associated with this case and was told that we had everything. So at this point, I'm not exactly sure where the gap was between that request and us receiving these surveillance videos. But at this point, I did not receive them until after 11 p.m. last night.
Your Honor, I received them at 8:30 this morning. Once Sister Counsel told me that they were in my inbox. And according to the police report, they were downloaded on January 24th of 2023. So they
Downloaded to.
police report just says they were downloaded. I'm not sure if it was to evidence.com or where it was downloaded to. That would be my assumption. And this case has been going on for nearly 15 months. So I would also object to the adjournment.
Your Honor, I checked evidence.com yesterday. I had 4 videos, actually, or 2 videos, I believe. I did not have the surveillance video yet.
And these, the description that the court got was that they're ring videos of, what are these videos? Yes. Ma'am, you can have a seat. No, you can sit right there. Okay, it's okay. They have to stand, but
They're surveillance videos of the victim's home.
from where? No, I mean, I guess I'm trying to figure out.
It's surveillance videos, ring videos, which the ring systems are operated by the victim, equipped to his home, and include video of the alleged conduct by the defendant.
And those are the only videos in this case.
There's body cam, and that was already submitted and uploaded into evidence.com, which was the video that I had available to me prior to 11 p.m. yesterday.
That's what I'm trying to figure out. What I'm trying to figure out is, Mr. Hall, when you reference something in the police report that says the video was downloaded, are we talking that video or are we talking other video?
It says David emailed me, here's the surveillance videos of his front and backyard.
Got it.
I downloaded them on my computer.
Okay.
My understanding, Your Honor, is that they were downloaded to the internal Pittsfield public safety server, but not uploaded into evidence.com. I don't know what the gap was when I asked for all media associated with this case, why they were not uploaded.
Did we ask why that happened, or?
I have not had an opportunity to hear back from them as to why that did not happen.
And you viewed the video?
Briefly. I viewed the original video, which is body cam of the video on a computer.
Say that again.
So
the other videos you've seen and viewed those.
Body cam video, yes.
Right. This video is the one that you're saying you just saw this briefly.
Yes. The ring video, they're much clearer and
they're clear.
yes. Those HD cameras now.
Yes. I have like 8 of them. And your grounds for objecting to the adjournment is solely because of length of time, as opposed to
Well, that and, well, yes, and this case was, there was a plea offered and entered into at some point, and then that, during the pre-plea version, that plea was pulled, and it continued on the trial, and a resolution was never reached.
I don't think that's an accurate statement of the record at all, plus we don't do pre-plea diversion in this court.
So I don't know what that is.
Maybe it was just a regular diversion.
There was no diversion in this whatsoever.
Yeah, I can help. This was a case where Patricia Reiser had offered, if she was to complete a mental health assessment and recommended, recommendations of a therapist, along with do not violate the state law for 3 months and no contact with the brother for 3 months, that the case would be dismissed. My client did, or Miss Julian did do everything required under that. However, after it was completed, the plea was essentially pulled. She was no longer able to do that.
Your Honor, we have been over this multiple times. There was no note of that offer whatsoever made.
Well, I understand that, but
It also wasn't discussed with the victim whatsoever.
well, that might be somebody else's issue. All right. So
And after,
was that offer given?
Your Honor, I have not been able to confirm either way, but what I do know is we had went on to additional negotiations afterward where another offer was formally recommended, offered and discussed, and we had agreed on it.
No.
Your Honor,
If the offer, so
Patricia Reiser, in the case, me and Morgan Barroso were on a Teams chat. She did confirm that the offer was there, and that was the offer on I think it was the second final settlement date.
And Miss Julian also did the psych evaluation. She completed it, and a report was produced.
And I do have that report available. I can print it off if you'd like.
That was not my understanding of the communication with Ms. Reiser.
okay, so hold on a second, folks. If I guess, was there, Ms. Kuhn, something to your understanding or anybody's understanding that if that offer was made, that as to a reason why it was pulled?
Because the victim did not agree to that.
And
Was
then-
the reasoning that was given.
And there was a change in the APA, correct?
Yeah, and there was.
There was a what?
Change from Patricia Reiser to Morgan Barroso.
Your Honor, it wasn't that the victim didn't agree to it. The victim was never consulted about any resolution whatsoever, which he is entitled to because he claimed his victim rights under the Crime Victim Rights Act.
But that's not my client's responsibility to make.
Well, okay, I get that. I hear all of that, but I mean, I guess the problem that I have outside of the alleged victim, their approval or their whatever, at some point, Ms. Julian is told to do something. She's told to do something that is sort of the ultimate resolution. That being, the case would be dismissed if you do these things. It's not, if you do these things, we'll give you a misdemeanor or something along those lines, that you still have to plead to something. For her, it goes away. And so then so from my understanding, and folks can correct me if I'm wrong, she does those things.
Correct.
At that point, then, I guess, the victim is contacted, the alleged victim is contacted, doesn't agree. And then and so then that offer doesn't happen. There's
Your Honor-
something wholly wrong with that whole scenario.
Your Honor, my understanding is not that the victim was contacted, it was that there was no documentation of that offer whatsoever. And the victim
Well,
was,
but Ms. Barroso, that's not my issue. My issue is that there was an agreement to do something. Defendant does it. Now, if on that side, what you needed to do wasn't done, that's a whole other thing. But I don't. Stands in recess.
All right.
Yeah.
You guys got through that. You got through what the communication I have. All right.
that is not correct,
What's not correct?
that she did not complete it,
That what?
that she did not complete it. I went back through my emails and on February 8th, prior to the February 9th final settlement conference, I forwarded along what Ms. Coombs sent me about what Ms. Julian had done to Vapa Riser and asked her if this passed muster for an offer, if there was one extended, and I never received a response. There was nothing from Ms. Riser. There was nothing documented about an offer. There was nothing documented about a dismissal in our file. Without anything documented in writing about an offer or a dismissal, we appeared the next day and we had the conversation in your chambers about how I didn't have any information about it, and without any confirmation, I did not feel it was appropriate to dismiss the case, so it was set for bench trial, especially with the victim being present on that day.
Okay. So, okay.
Your Honor, I have an email here from Ms. Coons to Ms. Julian on December 8th, and it specifically outlines the plea offer, no contact with the victim, no violation of state law, and get a mental health evaluation. And then I also have a mental health evaluation that was done on the 28th, and then a follow-up from the mental health coordinator on February 1st. And
I don't think the people are, I mean, from what I'm hearing, she's not disputing.
That was conveyed to Ms. Riser. I just did not receive anything saying that that was an offer from Ms. Riser, that was confirmed. I understand that Ms. Coons is saying that there was a Teams message on the day of final settlement. My response to that Teams message was not explicit that that was the offer that was extended. I did not understand it that way.
Your Honor, if I can, I laid out the offer inside the Teams message and I said, can you confirm this is the offer? To which Ms. Riser replied, yes, that is the offer. To which Ms. Barroso had replied, the victim did not consent to that, and that was the issue.
We don't have.
And then it wasn't until February 9th, which is the day after the 3-month period had run, and Ms. Julian was coming to court thinking that her case would be dismissed that day, when the rug was pulled out from under her and the offer was supposedly withdrawn.
On what day?
February 9th.
I'm not disputing any of that. I'm doing the best with the information that I have that was not confirmed to me.
I mean, the agreement was that she completed the
Folks,
the 3
folks,
things.
everybody stop. Everybody just stop. I get what the agreement is. I have now this communication from Ms. Riser that's her recollection of the agreement. I also have at least confirmation in my understanding that Ms. Julian did what she was supposed to do under the agreement of the parties, or that was between the parties at some point. The issue here, however, is, I guess, that the victim did not or wasn't consulted about it. But that's not what I am taking, and I don't know if we need to have Ms. Riser here. This is certainly her recollection, but specifically in the communication she sent, Ms. Riser was of the belief that the victim has said that they were okay with that resolution and that ultimately out of all of this, they wanted to be left alone.
Yes, and
But now I'm hearing today that the victim is not okay with that resolution.
My understanding is that resolution was not even raised with the victim as a potential resolution.
Donna, the victim was at the final settlement conference. From my recollection, there was a conversation on what his sentence was at that time. It was mental health and the no contact, and it was a creative solution. The plea was.
But you were, I understand what you're saying, Ms. Coons, but you weren't a part of that communication. You believe that there was a communication that may have taken place either with the victim's advocate or with Ms. Rice, with the alleged victim in this case. Is that right? I mean, you're giving me your impressions of what you thought a conversation that happened.
Correct, but I was not a part of that.
And on this day, I'm presuming the victim is here.
Yes, he is.
He is not okay with the resolution that was.
After all of this, he says whether we have the trial today and go forward with it or dismiss it, he is going to just be seeking a PPO. He says he's just tired and just wants to be left alone. So if we're not proceeding today, that's fine. If we are proceeding today, that's fine. He's been run through the ringer. He just wants to be left alone and will be seeking a PPO, whether it is stipulated to or not. That's all that he is caring about at this point.
And based on that and everything else, Your Honor, I would move to dismiss.
Well, I get to deny your motion. Okay, I could dismiss it. Because the agreement, there's an acknowledgement of the agreement, but and I had my staff check too, because if the agreement had been placed on the record, then everybody would be stuck with it. It wouldn't matter. But so my understanding now, I guess, based upon what you said, Ms. Barroso, is that the victim in the case is indicating exactly what Ms. Reiser has said. They said that they just want to be left alone.
That is the first time he has said that today. In all of my conversations with him and all of my advocates' conversations with him, I was speaking over the case. That is the first time I have heard that out of him. But at this point, he's now appeared 3 times and he's done.
Well, maybe not. What I'm inclined to do is your client was trying, I don't know if she was trying to say something to you. She may want to mute the microphone if she's saying something.
They haven't had contact in over a year and a half, so it's not like, she's stalking him or trying to get a hold of him. She doesn't want contact with him either.
Can I talk? No?
Well, here's what I'm inclined to do, folks. What I'm inclined to do, and I will be very careful how I say this, but I'm inclined to disallow the evidence that was just provided and exclude it from any trial and just proceed to trial on the matter if the parties can't come to some resolution. In doing that, I want to make it very clear that I'm doing that because defense counsel just got that information, but in no way am I making that ruling attributing that there was any indication that the Pittsfield Department of Public Safety or Officer Ritzler was attempting to try to not provide that information. And I say that because this officer's been before me for a couple decades, maybe, I don't know, 20. So right after I started, so in a quarter century. Anyway, and has always been forthright would not engage in anything to withhold anything. I would see it as being an error, but that error in terms of it happening and then ultimately getting corrected has inured to what may be a not a benefit to the defendant, and certainly may cause, so I haven't seen the tape, so I don't know, but may cause some issue. So what we'll do is I won't allow it. We'll proceed to trial. And you guys have 15 minutes to get yourselves ready and court's in possession. And there's been a in-chambers conference. I'm going to adjourn the trial out to, what date is that?
May 1st.
Jury trial to May 1st, 2024 at 9 a.m. That's a special time. All right.
Just to put it on the record.
Yes.
If I get the order signed before then, the hearing will be.
The trial will be canceled.
And the case will be dismissed.
Dismissed. Is that correct, Mr. Hall?
That is correct, Your Honor.
All right, very good. We have that all on the record. Okay, thank you, folks.
Thank you for your time.
This hearing began as a bench trial setting, but quickly turned into a dispute over newly discovered surveillance videos and an alleged prior plea agreement. Defense counsel informed the court that surveillance ring videos from the alleged victim's home were only received after 11 p.m. the night before trial, despite prior requests for all media. The prosecutor acknowledged the videos had been downloaded by police in January 2023, but apparently were never uploaded into the evidence sharing system. Defense objected to their late disclosure and requested an adjournment to properly review them. The prosecution opposed adjournment, noting the case had been pending for nearly 15 months. The judge questioned how the gap occurred, but ultimately focused less on blame and more on fairness, signaling concern that late disclosure could prejudice the defense. The hearing then shifted dramatically to a deeper issue: whether the case should have already been dismissed under a prior agreement. Defense counsel argued that a former assistant prosecutor had offered a resolution in which the defendant would complete a mental health evaluation, follow recommendations, avoid contact, and not violate the law for 3 months in exchange for dismissal. Defense maintained that the defendant completed all required conditions, expecting dismissal, only for the offer to be withdrawn after a change in prosecutors. The prosecution countered that there was no formal documentation of such an offer in the file and no confirmed approval, particularly from the victim. The judge pressed both sides on what had actually been communicated, noting email evidence suggesting an offer had been outlined and completed, but also highlighting that it was never formally placed on the record. A key complication was whether the victim had been consulted or agreed to the dismissal terms, as required under the Crime Victims' Rights Act. The judge expressed frustration that the defendant may have completed agreed-upon conditions only to have the resolution fall apart later due to internal communication failures. At the same time, the prosecutor stated that the victim was present and now simply wanted to be left alone, possibly seeking a personal protection order regardless of trial outcome. Faced with these inconsistencies, the judge weighed whether to dismiss outright but declined to do so immediately because the agreement had never been formally recorded in court. Ultimately, the judge ruled that the late disclosed surveillance videos would be excluded from trial to avoid unfairness to the defense. The court emphasized that the exclusion was not due to intentional misconduct by police, but rather the practical effect of the late production. The judge gave the parties time to prepare, but, after an in-chambers conference, adjourned the trial to a later date. The court also indicated that if a formal order reflecting the prior agreement were submitted and signed before the new trial date, the case could still be dismissed. The hearing concluded with the trial adjourned, the disputed, evidence excluded, and the possibility of dismissal still open depending on how the documentation issue is resolved.